Hello and welcome to another instalment of Wakeman's series of podcasts concerning affirmative pandemic insurance cover. This comes in the lead up to our question time discussion taking place at 11 a.m. on Thursday the 7th of May, which will be hosted by my partner Ed Lewis. The panel will be comprised of me, my colleagues Amy Nesbitt and Pam Freeland, Sir Bob Neal MP, who is Chair of the Justice Select Committee, Graham Trudgill, the Executive Director of BIBA, and Jerome Kirk, who is the London Markets Lead Partner at PwC. I do hope you'll be able to join us. I also hope you've had an opportunity to read my partner Simon Durkin's article concerning business interruption insurance issues in the context of the coronavirus outbreak, published on the 6th of April, which feels like a very long time ago now. We're into early May. As Simon notes, cover under a business interruption policy will typically be triggered by damage being caused to insured property. So what is damage in this context? Well, there are several key authorities relevant to the issue, and I'm going to discuss two of them now. The first authority we're going to look at is the 1990 decision of Mr. Justice Gatehouse in Merlin and British Nuclear Fuels plc, which concerned a claim by homeowners for compensation under Section 12 of the Nuclear Installations Act 1965. That Act provides for the licensing of nuclear reactor sites. Section 7 of the Act imposes a duty on the licensee to ensure that no damage is caused to the property of any third party due to any occurrence on site involving nuclear matter. And Section 12 provides for a right to compensation where damage is caused by a breach of Section 7, amongst others. The claimants alleged that their former home had been damaged by radioactive material released into the Irish Sea from the Sellafield nuclear plant, which had ended up in the house as dust. Mr. Justice Gatehouse found that the 1965 Act required that physical damage be caused to tangible property. He rejected the submission that the house included the airspace within it, or that the physical structure of the building had been damaged by the presence of radioactive material. The fundamental point was that while it had been contaminated, the property had not been physically affected by the presence of the radioactive material, and accordingly, there had been no damage to property for the purposes of Section 7 of the Act. The claimant's loss was purely economic and therefore irrecoverable. The second case concerns the 1995 decision of the Court of Appeal in Hunter and Canary Wharf Limited, or to be more precise, the related matter of Hunter and London Docklands Development Corporation. A large number of claimants sought damages from the LDDC in relation to substantial quantities of dust which had fallen onto their homes during the construction of a nearby road. The court was required to determine as a preliminary issue whether the deposition of excessive dust on property is capable of constituting damage to that property. The answer was provided succinctly by Lord Justice Pill, with whom Lord Justice Waite and Lord Justice Neal agreed, so I hope you'll indulge me while I simply read out the relevant passage. In my judgment, the deposit of dust is capable of giving rise to an action in negligence. Whether it does depends on proof of physical damage, and that depends on the evidence and the circumstances. Dust is an inevitable incident of urban life, and the claim arises on the assumption that the defendants have caused excessive deposits. Reasonable conduct and a reasonable amount of cleaning to limit the ill effects of dust can be expected of householders. Subject to that, if, for example, in ordinary use the excessive deposit is trodden into the fabric of a carpet by householders in such a way as to lessen the value of the fabric, an action would lie. Similarly, if it follows from the effects of excessive dust on the fabric that professional cleaning of the fabric is reasonably required, the cost is actionable, and if the fabric is diminished by the cleaning, that too would constitute damage. Excessive dust might also be shown to have damaged electrical apparatus, and there could no doubt be many other examples. The damage is in the physical change which renders the article less useful or less valuable. On the assumptions we are invited to make, that, rather than any general concept of loss of utility, is the appropriate test. In the circumstances, I do not propose to consider whether the cost of preventative measures would be recoverable. I agree with Lord Irvine that the fact it costs money or labour to remove a deposit of material on property does not necessarily involve a finding that the property has been damaged. So there is an obvious symmetry here with Merlin in the sense of damage being a physical change. In the case of dust, where the contaminant is ingrained into the fabric of the property, or even where the contaminant can be removed, the fabric will be physically altered by the cleaning process. On that basis, one can see why a policyholder might struggle to demonstrate that viral contamination of property has resulted in some physical alteration of the property's fabric that could amount to damage for the purposes of a business interruption policy. However, Hunter also leaves open the prospects of contamination requiring professional cleaning to return the fabric of property to its uncontaminated state. Moreover, both of these cases appear early on in the chronology of the relevant jurisprudence, and there are other cases that should be taken into account when considering such issues, including the Ordula, also from 1995, Blue Circle Industries plc and Ministry of Defence from 1999, and Pilkington United Kingdom Limited and CGU Insurance from 2004, which are discussed by my colleagues in other podcasts in this series. I hope you found this commentary interesting and enjoyable. Please do join us to continue the discussion on the 7th of May and look out for more content from Watemans in relation to coronavirus and other topics. In the meantime, please stay well.